Right, well, it's 12 o'clock. Welcome everybody. Huge welcome to this event today. I'm starting us off on time because we've got such a jam-packed agenda to get through, which is great. And I'm so grateful to all our participants for joining us. It's a hugely important conversation to be having right now and to continue having as the government proposals in the new plan for immigration progress through to legislation, alongside, of course, the review of the modern slavery strategy. And we at ECPAT UK share the feeling with many of you that the impact on child victims is too often overlooked and they get caught within very hostile systems. So without further ado, I'm going to hand over to Liz Barrett, who I'm delighted to say is the new chair of the board of trustees at ECPAT UK. We're really delighted. Liz is the joint head of immigration at Bindmans and has acted in many cases involving children who are unaccompanied and trafficked, as well as for looked after children. And she's also got tons of experience and expertise in governance, and has been was a former trustee and chair of the trustee board for the charity Bail for Immigration Detainees, obviously friends of ours here at ECPAT. Before I hand over to you, Liz, I've got a really important thing to do, which ECPAT often forgets to do. If you can go on to the next slide, Lois, which is to say that thank you, that we are fundraising, and we always find it difficult, I think, at ECPAT to say that, but this is an event happening in the Big Give week, which means every donation that we receive this week is doubled. We've got a very modest ask around, we're trying to raise £4,000 this week, but if you, obviously, this is a free event, but if you do feel you can donate to us, then please do. Thank you. Liz, I'm going to hand over to you. Thanks so much.
Thank you. Thanks very much, Patricia, and thank you for that very warm welcome to me. And I'm really delighted to be here today. And this is my first official activity as chair of ECPAT, and I'm really pleased to be here at this event. I'm really looking forward to hearing all our speakers. It's a very important issue, as Patricia says, and we've got some great speakers with us today. And I'm just going to briefly introduce everybody and then hand over to our first speaker. So our first speaker will be Kamena Dorling, Head of Policy and Advocacy at Article 39 and Head of Policy at Helen Bamber Foundation. Philippa Roberts is with us. She's Director of Legal Policy and Solicitor at Hope for Justice. Sirel is with us, Legal Director and Partner at JustRight Scotland. Temi, Youth Programme Assistant at ECPAT, will speak. Musa, Children's Society's Youth Campaigner, will speak following Temi. And then finally, Durán, Senior Policy Officer at ECPAT, will speak. So without further ado, I'm going to introduce and ask Kamena to start her presentation. We are on a bit of a tight timetable, and it's partly my job to keep everybody on time. So I will be doing that as much as I need to. But over to you, Kamena. Thank you very much.
Thank you. I am just going to try and share my screen. Sorry. Can everyone see that? Yep, great. Oh, I need to go back one. Oh, okay. You're going to miss the lovely snazzy beginning with the logo. Thanks so much for inviting me to talk today. This is a really, really important discussion. As Liz said, I work for Article 39, which is a small children's rights charity focusing on children in institutional settings, and also Helen Bamber Foundation, which works with survivors of trafficking and torture. And I've worked on age assessments as an issue for a really long time. So I just thought I would start. I'm sure most people watching know an awful lot about age assessments. I thought I'd just start when we're thinking about the impact of proposals on child victims of trafficking by outlining why this is such an important area. And of course, the obvious one is that age is not only fundamental to one's identity, but also for children coming to the UK, it determines what support and protection they receive. So how old they are will determine whether they get support from local authorities, what education they might access. If they're treated as over 18, they may be placed with adults in adult accommodation or in detention. And it will also determine how their asylum or immigration claim is processed. So it's absolutely fundamental. But of course, a lot of children arrive unable to prove their age because they don't have any documentation, or they have, which is significant for child victims of trafficking, they've arrived on false documentation, often because it's easier to travel and go unidentified if you're traveling as an adult. It's obviously incredibly difficult without documentation to assess how old someone is. And we have kind of two processes in this country. One is very cursory assessments made by Home Office officials, which is basically looking at someone and making a decision on their physical appearance and demeanour, and then more detailed assessments that are carried out by local authorities, specifically social workers, who are meant to kind of engage with the child, but also collect evidence from a range of other professionals working with them and carry out a kind of holistic assessment. On both sides, this whole process can cause a lot of confusion and frustration for children, and it can have a really negative impact on their mental health. Some can find it very re-traumatizing. And of course, while this process is going on, they're often prevented from accessing the support and education that they should be getting at the time, or worse still, from a safeguarding perspective, as I said before, they can be accommodated or detained with adults. One of the things I'm going to talk about is a Home Office policy whereby they will look at someone and make an assessment and can decide just to treat that person as an adult without doing any kind of further referral or assessment. It used to be that they could make this decision if that person looked significantly over 18. That was challenged in a legal case called BF Eritrea, and so the policy has been changed so that the person in question will have to look over 25. But this is an ongoing issue of dispute, which I'll talk about later. Just in terms of some sort of statistics for you, I have to sort of apologise, I don't have anything that's specifically about child victims of trafficking. All of our statistics tend to be bundled up with asylum in general. But what we know is that in 2020 and 19, we had 1,530 age disputes recorded by the Home Office. Half of those were subsequently found to be children. It could be a greater number than that because we don't know how many of those decisions went on to be overturned. We don't have any statistics on the children who are just treated as adults by the Home Office and then turn up later on, and that's challenged. And of course, one of the really significant things is it's not just about over 18, under 18. A lot of these challenges are about what age they are, even if they're acknowledged to be a child. So to go on to the proposals in the new plan for immigration, they're deeply frustrating and they repeat a lot of the conversations we've had for many, many years. And as with a lot of things, it feels like the government has absolutely no institutional memory on this issue. But one of the proposals in the new plan is to introduce a duty on local authorities to assess age, where they believe that someone's age is being incorrectly given. It's not entirely clear to us why they're trying to do this, because statutory guidance already makes it clear that age assessments should only be carried out when there's reason to doubt that the individual is the age they claim, and they shouldn't be routine. So not sure why they want to legislate on this issue, but if they do, it's really important that it's done in recognition of the Modern Slavery Act, making clear that where there's reasons to believe that they are a child is presumed to be a child, that they don't lose that bit of support while the dispute is ongoing. Another proposal, which on the face of it looks fairly okay, is the creation of a national age assessment board. This appears to be trying to address the fact that there is a wide sort of disparity in practice across local authorities in terms of how they undertake age assessments. So the idea is that this board would be made up of social workers, very skilled in undertaking assessments, and they would carry them out where required. How they do that across the country, how they do that in the devolved nations, which is something that Andy might talk about, is really unclear. But also the idea is this board is situated in the Home Office. So the idea that it's going to be truly independent is questionable. One of the things the board would be tasked with doing is setting out the criteria in secondary legislation for undertaking age assessments. Now, this already exists. we have kind of different guidance in the different nations, but in England, we have guidance from the Association of Directors of Children's Services. It's very long, it's very detailed. It took months to put together for a very good reason, because this is a complicated area and social workers need a lot of guidance and structure around how to do this. The idea that you can sort of make it much more simple just by putting it in secondary legislation is completely misconceived. And as far as I can tell, it's actually just a vehicle for the government to be able to legislate on the issues in which it's been challenged in the past. So one of those is we've seen an increased use of what are called kind of shortened visual age assessments, which can be carried out by social workers, but they're very similar to the Home Office style, which is, let's look at you. Okay, we think you're not the age you claim you are, and we're going to do this very kind of abbreviated process. One of the things that the Home Office clearly wants to legislate on is their ability to find a child to be an adult based on their appearance as being over 18. As I mentioned before, this has already been looked at as a policy by the Court of Appeal, which found that this created a significantly greater risk of children being unlawfully detained as adults. It's been heard in the Supreme Court, and we're still awaiting the judgment. But the Home Office seems determined to try and legislate, sorry, its right to do this on the basis that its current policy of over 25 years of age is leading to adults being referred to children's services. We've asked, and they don't actually have any evidence for this, but they seem kind of determined to legislate anyway. And in our view, that will just create unnecessary risk. Also, what is the point of having a legal process if you're presupposing what you're going to do before you've had the Supreme Court judgment? Another really concerning area is the proposal to revisit the idea that you can use scientific methods, so it's commonly like x-rays of bones or looking at teeth, as a means of working out how old someone is. This has been rejected by professional medical bodies, and here you can see a quote from the RCPCH's current guidance that basically says use of these scientific methods is imprecise, and actually it's not appropriate for children either. But we see this happen every few years. A new minister comes into post and goes, oh, this is clearly the silver bullet for solving age assessments. But it's something we really need to push back on, because actually in the UK's practice in this area is pretty good compared to the rest of Europe, and we don't want to go backwards. I think one of the only really kind of strong areas in the new plan that we might welcome some changes is the introduction of an appeal right against age assessment decisions. At the moment, you can only challenge the decision of an age assessment through judicial review. This is expensive, it's really long, it's stressful for everyone who's involved, and children can have their kind of lives left on hold while they're waiting for a final decision. So the government's looking at a statutory right of appeal to the first tier tribunal as a means by which age assessments conducted by local authorities or the new board could be challenged. Now, of course, the problem there is what about the challenge to assessments carried out by Home Office officials? Also, there are lots of outstanding questions about the time frame. At the moment, judicial review, you have 3 months to bring a challenge, whereas with appeal rights, usually 2 weeks. There's a huge issue about jurisdiction. Again, Andy might talk about that, but what happens if you've got a child assessed in England and then they move to Scotland or similar? And so if it sped up the process, if it made those decisions a bit fairer, it could be a really good thing, but we're just not clear at this stage, as with a lot of the new plan for immigration, often very light on the detail, and we remain to see how it's going to pan out. So my final kind of thoughts on the package as a whole, it's really not clear what problem they're trying to solve. You can't, the issue of age, the issue of how you assess age will continue to be complicated, and you can't just legislate it away. You can't just make it simpler by putting it into legislation. As with so many things, the aim is to prevent abuse of the system rather than focusing on how you safeguard the most vulnerable. And what we really don't want to see is an increased risk of children being accommodated with adults, detained with adults, and all the safeguarding risks that brings. We have to look at it from that angle. Government looks at it from a, oh, you can't place adults with children, that's really, but it's not, because it's a different thing. If you were placing an 18-year-old in a supervised kind of placement with a 15-year-old, that is a different thing to placing a 14-year-old in immigration detention. The proposals don't actually address local authority practice. What we need to see is better training, we need leadership, and we need more resourcing to improve how age assessments are conducted. And as I've mentioned a couple of times, how on earth does this work with devolved administrations? And fundamentally, why is the Home Office trying to legislate, I wouldn't finish that sentence, for what is at heart an issue of children's social care? So lots of issues to work through and lots of problems to try and address. Thank you.
Thank you very much, Kamena. That was a very clear exposition of all the issues that are facing. And as you say, many of us will feel like we're going around the block on this, in particular looking at so-called scientific answers to what is a very complex issue, and as you say, cannot be made simple. I'm really sorry, I forgot to say at the start that anybody participating, please do use the Q&A feature, and we will try and pick up the questions and answer them towards the end of everybody's presentations today, time allowing. So please do feel free to use that. So our next speaker is Philippa Roberts, and Philippa, can I pass over to you, please? Thanks.
Thanks. I'll just share my screen now. Okay, hopefully everyone can see that. So yeah, I'm Philippa Roberts. I work for an organisation called Hope for Justice. Just to give you a brief insight into what we do, we're an international organisation, and we exist to end slavery by preventing exploitation, rescuing victims, restoring lives and reforming society. Predominantly, we do work with adolescents and adults in the UK, but internationally we have a number of offices working with children too. And we work across 5 continents. So I was asked to speak around the new immigration plan and the public order exemption. So just to clarify what we're meaning by that, so there's always been provision within the Council of Europe Convention to allow member states to have a public order exemption with respect to the recovery and reflection period, i.e. that the parties may not be bound to observe this period if grounds of public policy or if it's found that victim status is being claimed improperly. The explanatory report has very little information, but does clarify really the thrust around this is around victim status not being legitimately or illegitimate claim of this. And then we start to see within the statutory guidance on modern slavery, this kind of provision appear in domestic guidance of the recovery and reflection period will not be observed if public order prevent it or it's found that victim status was claimed improperly. Now, arguably, the provision is harmful, but it's even more harmful if it's not clarified what that means. So within the new immigration plan announcements, there was a proposal to clarify what is meant by this in consultation. The thrust of this within the plan was to identify victims as quickly as possible, enhance supports whilst distinguishing more effectively between genuine and vexatious counts and enabling the removal of serious criminals and people who are a threat to national security. But this is a concerning feature because what is defined as serious criminality is a sentence of 12 months or more, or whether risk to national security. Really, the thrust of the public order is to prevent somebody, a victim of potentially serious crime, from being able to access a recovery and reflection period and safeguarding and the support they need. So the threshold for such a provision really should be at an extremely high level, in effect. So what are some of the challenges around this? You obviously have this wider context of the immigration policy, which will invariably impact on children more widely and potentially place them at risk of exploitation. But it's also feeding into this public policy, really concerning public policy narrative around victims of crime, into this incorrect narrative around victimhood and this myth of the perfect victim, that there are deserving and undeserving victims, and effectively also blaming victims, particularly if they've committed offences as a result of their experience of exploitation. Concerningly, there's been no data or impact assessment to justify these changes. And actually the very, very limited data available that I could find on foreign national offending showed that there are over 10,000 people entering the NRM. There were less than 200 people, foreign national offenders, who were claiming that they were trafficked and wanted to be referred into the NRM. And there's no data on how many of those are actually committed serious offences or actually committed offences as a result of their trafficking experience and subsequently went on to receive a positive, reasonable, conclusive grounds decision. And even more concerningly, this completely impacts particularly on children. And real concern that it will discourage people from coming forward, receiving their safeguarding and support they need, particularly as the NRM data is showing significant proportions of children have been exploited for criminal exploitation. And we know from significant research over the last few years that child victims are still not being identified in the criminal justice system and often being wrongly convicted. And also some victims just aren't able to avail themselves of the statutory defence because of the wide exemptions within the Modern Slavery Act. Also, I just wanted to as well point out, if offences occur in another country, sentencing is often really high and can be really high for minor offences. And actually it's important we understand the context of the criminal justice system in other countries, that there could be significant corruption, a lack of legal advice, and people could be convicted of offences wrongly, even in their own country, which could be related or not related to their trafficking experience. Also, it appears from the announcements that this would be, applied to pretty much all cases running through the system. It adds an unnecessary layer of administration and an unnecessary layer of scrutiny. The reason why the reasonable grounds threshold is set so low is to ensure that there is time to actually look at the full case and assess whether someone is a victim, and so that they can receive appropriate safeguarding and support. And actually, if you think about it, there's no other crime that we ask victims to do that, to even give, significant, if somebody claims that they're a victim of rape, that's accepted, and then investigating the person is safeguarded and supported straight away. There's also a real lack of clarity on this and how this synergizes with national and international obligations towards victims of crime, which there are obviously wider international obligations towards victims of crime here, and we're talking about victims of serious crime. And that concerningly also is, how does this synergize or impact around wider children's rights internationally, and particularly their concerns around paramilitary and non-state groups who exploit children, including how this impacts on the international framework on the use of children in armed conflicts. Currently the statutory guidance is completely silent on these issues. And regardless of whether you could have a national security issue, with a child, you have a child safeguarding issue as well. And it's important to see that context. What doesn't appear to be looked at is actually the potential impact on the victims of trafficking, but also the protection of the public from serious crime. And we're often talking about serious crime. So in 2018, the Home Office estimated the socio-economic cost to society of modern slavery were between 3.3 billion and 4.3 billion pounds. So there's a really urgent need to ensure that victims can come forward without being penalised, engage with long-term support, which in turn enables them to make choices such as whether to cooperate with criminal investigations. So, well, if I was talking about a recommendation, I would be talking that the public order exemption is not instigated at all, if I'm being really honest, especially for children, because I think the impact on victims it would be so much higher than the potential thrust of this, which is to root out vexatious claims, for instance. But if it is, and the government are consulting on this, and they do need to consultate with all agencies and survivors, but the government needs to be transparent on the data to justify this position. And it should always be a case that the responsibilities to identify, safeguard and support children should be paramount. The setting of a threshold to effectively deny a potential victim of a serious crime access to safeguarding and support should be extremely high and shouldn't be applied in all cases. We're talking about really exceptional circumstances here, and actually any application should take into account all the circumstances of the case, especially the child safeguarding issues and risks of re-exploitation. There also needs to be really clear guidance on this, including for decision makers. Again, taking into account all the circumstances of the case, and it should have a clear appeals process. That appeals process, victims throughout the entire process should be able to access legally aided advice and representation, especially pre-NRM, including on any wider changes made by the plan, such as this. And there needs to be a drastic improvement of first responder and decision maker training, which would include training on any public order exemption. Finally, this really needs to have clear data attached to it with a clear monitoring and evaluation framework to really assess whether it's achieving its aims of rooting out, for instance, vexatious claims. So, as I say, in terms of it overall, our view would be we wouldn't want this instigated, but I think we've got to be clear that I think the government are going to follow through and instigate this, but we need to ensure that it is as narrow as it possibly could be. Thank you very much for allowing me to present.
Thank you, Philippa. And if anything, needs to remind us of just how little children have been put into context in this whole immigration plan. I think your presentation really brought that home. So thank you. So our next speaker is Andy Sirel. So could I ask you to take over, Andy?
Sure thing. Thank you very much. Let me just share my screen very briefly. There we go. I hope you can all see that. So thanks very much for asking me to come along and speak. My name is Solicitor at JustRight Scotland. We are a legal NGO based in Glasgow. We have projects working both in refugee and migration, but also specifically in anti-trafficking and exploitation as well, amongst others. I'm here to speak today about the impact of the new plan on child victims of Scotland and devolved administrations, but I'm going to be specific for obvious reasons to Scotland here. Much of it will apply equally to my Celtic cousins in Northern Ireland, lesser so to Wales, but obviously I'm going to focus in for an example on Scotland. So the new plan is, I'd originally written something different here, and I sort of brought it back to just using the word problematic because I didn't know what my other speakers would be saying on this. The new plan is problematic, let's put it that way, from a constitutional perspective. Reasons for that: human trafficking in Scotland is a devolved matter. Child law in Scotland is a devolved matter. criminal justice in Scotland is a devolved matter, and I could probably end my presentation there, to be honest with you. Human trafficking in and of itself, including the criminal prosecution of traffickers, the protection of victims, is devolved to the competence of the Scottish Parliament under the Scotland Act 1998. This is to get out there and accept. Human trafficking is fundamentally not an immigration issue. That has not landed with the Home Office, I don't think, but it needs to immediately, I think. The top nationality for NRM referrals UK-wide is every year, by a huge distance, UK nationals. This is not an immigration issue. It shouldn't really even be in the new immigration plan in the first place. So we can just start on that point. Let's look at what we have in Scotland, and there are similar acts in there's a similar act in Northern Ireland as well, albeit more tailored towards criminal justice. We have, so the new plan is littered with references to the Modern Slavery Act. It doesn't apply apart from maybe one or two sections in Scotland. We have our own Human Trafficking and Exploitation Scotland Act, and it diverges actually from the Modern Slavery Act in a few different ways. Sections 1 and 4 speak to making of trafficking and exploitation as separate criminal offences. Section 8 is the Scottish version of in England defence. In Scotland, we do not have a statutory defence. Instead, we have guidelines, instructions to our prosecutors about when and when not to even take a prosecution. So we've kind of taken that principle and put it even before a prosecution even happens, as opposed to a statutory defence, which is obviously invoked in the middle of a prosecution. Sections 9 and 10 speak to support of victims of trafficking and exploitation. We've got a 90-day rest and reflection period in Scotland. Section 11 speaks to guardianship. We have guardianship in Scotland. We've had it for 11 years now, and it's outstanding. Section 12, presumption of age. Section 38, duty to notify. Those are more familiar things for you there. Let's look very quickly at the reasonable grounds test proposal from a devolution perspective. The proposal in the new plan only seems to speak to the Modern Slavery Act and the statutory guidance. You know, when you're a lawyer in a devolved nation and you see things like that, you never know whether that's deliberate or whether the writers just didn't know that we have different things in devolved nations. That's a common experience, right? In actual fact, so as it's written, it looks like it's just applying in England. And indeed, sections 9 and subsection 8 and section 9 subsection 9 of our 2015 Act allow Scottish ministers to make provisions about what the legal thresholds are for reasonable grounds and conclusive grounds decisions, about the procedure, about how that's made, and about who makes that procedure. Now that means that actually the NRM is a devolved thing. We can set something up completely different in Scotland if we wish to. A legislative consent motion, you're going to hear me use that word quite a lot, I think. A legislative consent motion under section 28 of the Scotland Act would therefore be needed if any of these things, especially around the reasonable grounds test, was to be applied in Scotland. Now, when I talk about legislative consent motions, it's in the Scotland Act, but whether it's actually legally enforceable is a different matter, I think. The UK Parliament is sovereign, and the Gina Miller case from Brexit effectively told us that these legislative consent motions are more of a constitutional constitutional concept rather than a hard and fast law. So there's a theory in one camp that the UK government could just batter through devolution and force this through, which would be a legal challenge without a shadow of a doubt. Alternatively, they could decide to respect the devolution agreement and not force it through. And that creates this two-tier system of trafficking identification in the UK. It's more difficult to get a reasonable grounds decision in England than it is if you are north of the border. This is a theme we're going to see. And it's not an ideal situation. Let's move away from human trafficking legislation. Child law, that's devolved in Scotland. Now, it's impossible for me to speak about child victims of trafficking without speaking about age assessment. I'm not speaking about the context, the actual substance of the proposals. I endorse everything Kamena said in terms of her position on those. Child victims of trafficking are looked after by local authorities in Scotland under the Children's Scotland Act 1995, not the Children Act 1989. That doesn't apply in Scotland. Age assessment impacts almost every facet of a child victim's life. You know, whether they can receive care and support in the child protection system or in the adult system that we have here for within the NRM, whether they receive a guardian, which legal test this applies. Is it the child test or the adult test in terms of their identification, whether and how they're prosecuted and detained, access to education, all sorts of different things. There is not an aspect of their life that's untouched. I'm banging this drum. Just as human trafficking is not an immigration function, neither is age assessment. I think Kamena has already made that point. It's a process by which eligibility for child services is assessed. So social workers in Scotland do that. Are you eligible for Section 25 support under the Children's Scotland Act? And an age assessment tells you the answer to that question, if it's necessary. It's also very closely connected to Section 12 of the Human Trafficking and Exploitation Act. In fact, off the back of Section 12 coming into place, that's the practice guidance that we put in place. I wrote there March 2015, that's a mistake, it's March 2018. Sorry, that's my mistake. And when we look at the sort of the proposals themselves in the new immigration plan from a devolved perspective, Kamena has also mentioned the NABs, or NAABS, these boards. Difficult to see how they would apply in Scotland. In theory, it might be possible, but it would be there would be multiple questions around jurisdiction, composition of the boards. Would they have an understanding of devolved child law in Scotland from what it is in England? Who knows? What's easier to determine is the other thing there, legislation to place a duty on local authorities to either do an age assessment or refer to a NAB. That needs a legislative consent motion. Westminster passing legislation which decides what local authorities in Scotland need to do with their children is a long arm into devolved practice, devolved law in Scotland. The statutory appeal, I could probably speak to you all day on that. Creating an appeal mechanism against Scottish local authorities' decisions and omissions, the decision not to do an age assessment, is something that I think Scottish local authorities would have a thing or two to say. I'm principally in favour of not using judicial review as a remedy, but there are lots of jurisdictional things to iron out here. There's comments in the new plan about interim relief against local authorities. Again, this is flirting very closely with devolved law. Principally, this needs a legislative consent motion, in my opinion. And then you've got other questions like, what about legal aid? You know, we have a different legal aid system to the one in England as well. So problems there. And then the last thing I'll say before I finish up, completely agree with everything Philippa said on the public orders grounds exemption. Criminal justice is devolved in Scotland as well. This closely relates to Section 8 of the 2015 Act and the principle of non-punishment. We actually have a different framework for implementing the principle of non-punishment in Scotland. I've already told you about the Lord Advocate's guidelines. We don't have a statutory defence. And the way in which this works actually just now is under very close scrutiny at the moment, because we've seen a spike in adults and children victims of trafficking being prosecuted for Kamena. There's a recent case coming out of Strasbourg called AN and VCL against the UK, which all constituent parts of the UK are going to need to reflect on their processes here and come to a decision and come to a view about whether they're compliant with that judgment. And I suppose the problem with the public order grounds exemption from a devolved perspective is where practice across the four nations diverges as regards this principle, so too will the application of this public order grounds exemption. You know, if we have almost no prosecutions of victims of trafficking in Scotland, for example, then it's very unlikely this will come into play. If the English system works differently and they're much higher, then basically you're going to be more likely in England to get a public orders grounds exemption than you are in Scotland, and that could be vice versa. Who knows? So it's creating a multi-tiered protection system for victims. So just to conclude, I'll say it again: immigration and human trafficking are not the same thing. Conflating them, I think, is politically expedient. The new plan sets up various constitutional clashes with devolved nations, and I'm using some Scottish terms here in terms of how we look after our bairns or wains. If you don't learn anything else, now you can know in Scotland, bairns and wains. It creates the possibility of multi-tiered protection identification systems within the UK. That's not a positive thing. And actually, and this is perhaps more speculation reflecting on our own experience anyway over the past decade and a half, criminal organizations know these things. They know where to exploit, where to move their business to. And if victims obtain less protection in certain parts of the UK, there's an argument that they may well focus their business. Alternatively, depending on the type of organized crime and exploitation, they may actually focus their business on the parts of the UK where we have a higher protection. In Scotland, we see all the time victims released to us. They go through the system, come out with status on the other side, and then back to their trafficker, kind of a laundering type thing. So that organised crime groups will benefit from a multi-tiered system, and that is definitely not where we want to be. And that's.
Thank you very much, Andy. That was really, really interesting. And one of the really important things there is, and from everyone who's spoken so far, and I'm sure the next speakers as well, is the expertise around this this event just isn't reflected at all in that immigration plan. And I'm pretty sure, Andy, that nobody thought about it. Possibly it's deliberately, but I think there's clearly a lack of thought around how that's going to play out constitutionally. So thank you for that. Can I next introduce Temi Adekoya, Youth Programme Assistant for ECPAT. Thank you, Temi.
Thank you. Hi, everyone. Thank you so much for this opportunity. And first, I need to share my screen. Is that okay? Let's see. Oh, sorry. Share screen, please. Okay. Okay. Sorry, guys. Thank you for the opportunity, and I'll just briefly go straight to the point as I don't have much time. Basically, when I first heard about this new immigration plan, I was quite baffled by it. Reason being, it's very close home, and also that I have the opportunity to be working side to side with the young people that are still going through it. I see it, as you see from my title, I see it as a setup to fail. As there's a lot of things that I think need to be put into consideration, especially when you're dealing with a child. And this, I don't think is the impact has been talked about, because if we put this into consideration, this won't come to light. It will be something behind the closed door, that it will be improved, that everybody will be happy, as we can see that this is supporting a child, is putting the child best interest at the center of it all. And also, I see the approach. The reason why I see the approach as a setup to fail is because things, for example, when from speaking from experience, when the young person are going through this process and they're not able to talk about everything that happened to them, the journey, even some situation that happened in their life or their journey, or through the trafficker, they're not able to talk about it. This could be due to fear and the abuse, the trauma, the a lot of manipulation got through, that these children got through. It's just too much to expect so much from them. And being there myself, as old as I am, there's some things that before I didn't say as wrong or abuse. Then let's say, for example, a child meets that out or are not able to narrate that in a form that is acceptable according to what is proposed to be acceptable ground in order to pass through, and they're not able to do that. Does that then mean that that child would not get the right protection and support that they're meant to get? And this is quite traumatic for me, because it's traumatic enough, the journey that the individual child has gone through to lead to this, them being assessed in different places. It just says there's so much to even to take it in, the talk less of telling their own story, their situation. And which is one of the reasons that we have guardianship being proposed, as because I was a bit in the younger aspect when we're designing the poster, making video and stuff like that. I remember thinking that part of the guardianship, I want the person to be like an octopus. And the reason why I said that is because these individual children, they don't have parents that is looking for their best interest, and they don't have anyone than local charity and other NGOs that put their foot forward to stand up for them. Rather than that, they don't have anyone. So I feel like the person have to be able to be my mom, be my dad, be this, be that. So if someone like me is looking for that time I think I was 16 or a bit older, if I'm still looking for that, then what are we thinking about the younger one that are even younger? Even now, I need a mother if anyone can step forward, you know? It's not easy to expect so much from them. So I believe, and I will stand by it, that a lot needs to be put into consideration, because they need therapy, they need so much support to even reach the stage. But apparently, I don't think that is the window is open to have all this progression to get the support before all this interview, all this headache and stress take place, as that is the way it is. But it will be really nice, and if we can have a role to play in it in order to improve it. And to summarize it up, I believe this new proposal is completely unfair, and big concentration need to be, and big emphasis need to put into the impact that this will cause on the individual children and young people. Thank you so much, guys. And just to say before I go, just to show you guys the impact of this, is that some of the young people that I work with for a year now or over was still not being able to say, the individual young person talked to us about me and my colleagues, we're like, wow, this is something that's supposed to even take place from beginning of the process. But believe me or not, the young person just find the appropriate time, or maybe because they have built trust with us, that they're able to now then share what happened to them, that we're like, oh, we need to contact this, we need to contact this, that things need to take place to make sure that they're taken care of. We just come to show that this thing take time and it take a long process. Thank you so much, guys.
Thank you, Temi. I think that is a very timely reminder of just how important it is that all the children in these processes are listened to and given time, and that the processes are fair and they're able to give their account and be represented properly in that system. So our next speaker is Musa, who is from the Children's Society. Thank you, Musa.
Thank you very much, Liz, and thank you very much to everyone that is attending this event. I'm Musa from the Children's Society, and together with a group of other young people, that have all come together alone in the United Kingdom and have gone through getting rejected by Home Office, getting rejected by courts, and not having someone that can help us to make our case together, or bring our case together, and someone that we can talk to, and also help us, most importantly, to find a good lawyer, or help us to find the right support. I myself know how hard it was, because I have been rejected by Home Office, rejected by court, and for 3 years it felt like living into a delusional. This is why, together with a few other young people, and supported by the Children's Society, we decided that we need to make a change. And to do this, we launched a national campaign for guardianship. There is no doubt that guardians are important, and they make a crucial difference to all separated, trafficked, and all children and young people, because some of them come in United Kingdom from the age of 13, and picture yourself at the age of 13 going to another country, and you have no mom, you have no dad, you have no one that can support you, but also you have no but also the government from that country is not doing enough to support you. And there are some people that live like this and have all of these consequences that create a permanent mental health impact into their minds. There are long delays with asylum. There are problems with legal process. There are delays with their solicitors. And only yesterday I met with my first social worker, actually, for a catch up. And she said that we have nearly about 15 to 30 cases each. And even if we want to help every single one of you, we can't, because there are emergencies. We have to make sure that you are living somewhere, you are provided, and there are a lot of papers, but we don't know how other ways to help you. Or with immigration, we are not trained. We just make sure that you are placed somewhere, and there are other young people that have different kind of problems, and they don't really have the expertise or the capacity to help us. Not that they don't want, but they don't know how to, and they can't. That is why we knew that guardianship exists in Scotland and Northern Ireland, and we traveled there to learn how guardianship works. We met with young people to see what the kind of support they receive from guardians there. We met with guardians themselves, and we also met with lawyers, including our wonderful Andy Sirel that we just heard from. We have created a documentary about our trip and what we have learned. After gathering all of this evidence, we launched our campaign. And I'm proud to say that today more than 20,000 people have signed our petition and agree with us that guardianship is necessary. It's not that I'm not doing the campaign because I don't want other people that are coming now to go through the same journey. There are already thousands and thousands of people that are going through the same journey, and it's not that the system is at a breaking point. It has broken. It has broken, and we have joined with ECPAC, and we also met with parliamentarian. We have a story to tell because we know how important this is to us. And with the new immigration laws that they are coming, the pressure on young people is gonna grow, and guardianship is needed more than ever. Personally, as I said, I came alone in UK at the age of 17. I had no one. I went through rejection, and finally, after 3 years, I managed to change my solicitor, and I was granted leave to remain. As I said to Andy, only a few weeks ago, I finished my law degree, and in September, I'm training to become a barrister. And I cannot believe that from 17 years old, as an unaccompanied asylum seeker, in a year from now, I'll be a barrister. And I was lucky, blessed, or I don't know why, but I want also other young people that come here that have same dream, not just to be a lawyer, to be engineers, to have an opportunity to become somebody, not to suffer just because they don't have the immigration system. And I can leave just by saying it's wonderful to see that all of you are doing something to help us to introduce the guardianship, but we also need a little bit more support to make sure that guardianship is placed and to make sure that these people doesn't have to suffer, but can get that opportunity, become citizen, and just have a life, not a better life, but have a life. Thank you very much.
Thank you, Musa, and congratulations to you. And I think one of the things that really comes out from that is just the importance of a system that is consistent for all young people and children going through the system. The issue of guardianships being one that's been argued about with the Home Office for many years, and some young people are very lucky. They get good lawyers, they get excellent foster carers, they get excellent social workers, but it shouldn't be arbitrary. And it's good when it works, but for some people, they do fall through the net. So good luck with the campaign as well. I think it's a very important issue. So finally, we have Laura Durán from ECPAT. Laura, I'm sorry, we are running a little bit tight on time, but we very much look forward to hearing from you.
Thanks so much, Liz. I'm going to run through this very, very quickly. I am going to be talking today about two different parts of the new immigration plan as they relate to child victims. Really, really quickly, so that we can get to that Q&A session. Right. So the first thing, I think, Andy, you alluded to this in your presentation, and obviously, I think, Temi, you were also speaking about this, but one of the things that is concerning us at ECPAT the most with regards to the proposals is this part of the new plan for immigration where they're proposing to set out a new test at the reasonable ground stage. So a lot of you may know, and some of you may not know, that victims of trafficking, when they're identified, they're going through this two-stage process in the national referral mechanism. And the reasonable ground stage, since the NRM came into being after 2009, has always been at a very low standard for very good reasons. And the reason being that when somebody is suspected to have been trafficked at that very early stage, you have very little information to go on. You know, you may be relying on some trafficking indicators, on some suspicion, but there's not very much really to, by way of what the Home Office is wanting as conclusive proof or objective evidence. And we are really terrified that what this means is that they're going to raise this standard, which is very low for very good reason, to the point that it's going to screen out a very significant number of children at that very, very early stage. To put it into context, we did some FOIs at the beginning of the year to look at exactly how many children received the reasonable grounds decision. So just between January of 2016 to the third quarter of last year, there was 13,233 reasonable grounds decisions made, which were positive. So that's just the amount of those who have been potentially exploited as children that were referred into the NRM that received the positive reasonable grounds decision. If the standard is changed to this much higher threshold, a really big chunk of those are going to be screened out. And in children's cases, as Temi mentioned, you really do need, and I'm sure that also for adults, but within the context of child trafficking as being a form of child abuse, you really need to establish that trust in order for children to be able to disclose some of these experiences. There's so much well-documented research that shows that the disclosure of children is not a single event, but it's usually drip, drip, drip through a long period of time once they have their needs met and they feel like they have a person that they can trust in. So if we're already screening them out at this reasonable grounds stage, there's not going to be any possibility for children to be properly identified and then supported accordingly. So this is a particularly worrying proposal. Another proposal in the new plan for immigration is that they're planning to legislate what the Home Office is calling temporary leave to remain. We're not really sure why it's called temporary leave to remain, because their goal and aim is to legislate in line with their duties under the Council of Europe Convention, or ECPAT. But what they're saying is that this form of leave that they're going to legislate is to meet the long-term recovery needs linked to modern slavery exploitation. And they're only going to be eligible for this grant of leave for those who are helping police with the prosecutions or due to their personal circumstances, right? Now, there's absolutely no mention in the plan as to how these proposals are going to be legislated for children, but I think it's really important to highlight, just like the plan is silent on children in almost every section, even though there's a very specific legal standard as to the leave that children are entitled to under the convention, which is that it should just be issued in accordance with their best interests. So this threshold that they should be cooperating with a police investigation, that, you know, because they're accessing mental health support or because of their medical needs, does not need to be met. The only thing that needs to be met is if those who are looking after the child deem that it's in their best interest to grant them leave, and the length of leave should be granted in accordance to that. That's the only criteria. Now, why are we really concerned about the way that this proposal is framed in the new plan for immigration? Well, currently we have something similar to that in guidance, which is the discretionary leave to remain for victims of modern slavery. Now, in that document, it does state that this should be considered in the best interest of children, but somehow children are still not accessing it at all. So we also issued some FOIs to the Home Office to deem how many children were accessing this form of leave. And after they reviewed the data they had originally published, the new data shows that between that period of 2016 to 2020, we can't tell exact numbers. So it's a range between 16,045 and 2,230 children those who were exploited as children who got a conclusive grounds decision that were subject to immigration control. Out of that whole number, only 67 to 133 were granted discretionary leave in 4 years' time. So a lot of that group would have claimed asylum. And for those who claimed asylum, the refusal rate was 52%. So really, for child victims of trafficking with irregular immigration status that claim asylum, it's a coin toss, depending very much on their country of origin, whether they can access asylum. And none of them, I mean, less than 5% are accessing discretionary leave as victims of trafficking based on their best interest. So we're really concerned that they're being, again, completely neglected from leave policy. Now, we are relaunching our Stable Futures campaign, calling on the government to ensure that these considerations for children are taken into account. We're going to be focusing on the immigration leave ask, but I just want to highlight what young people tell us all the time. So this has been said to me more times than I can count in all the years that I have been working with young people, and is that state of immigration limbo as they are transitioning to adulthood has often felt worse than the exploitation they experience. And I really want that to sink in, because these horrific episodes of abuse to children, in their mind, the state of immigration limbo is worse, because they are completely stuck. They cannot recover, they cannot make life choices, they cannot access apprenticeship, they have limited access to the education very often. So I think this is one of the really key things that are missing in the considerations, that if proposals under trafficking are included in this new plan at all, which they shouldn't because they're not an immigration matter, the only one that is, which is this one, because it's about immigration leave, doesn't even account for children. So thank you so much. And I try to run through that very, very, very quickly so that we now can have time for some Q&A.
Thank you, Laura. So just picking up on one of the questions, I wonder, Andy, whether you might be able to answer this, because it was you who sort of put this central actually into the debate. One question is, how can you divorce human trafficking from immigration?
Sure. So there is no doubt that there are points in time where immigration requires to touch upon the lives of survivors of trafficking, migrant survivors of trafficking in particular. And I would love to see a world where when somebody is identified as a victim of trafficking, they're automatically given leave to remain, right? And then their asylum claim, if they have one, is then decided afterwards, whatever. But the idea that that how we protect and support survivors of trafficking, how they benefit from rights to compensation, how they benefit from principle of non-punishment, how they benefit from all sorts of other elements that are in legislation and our international obligations, the idea that that's somehow linked to where you come from is not correct. Around a third of referrals every year to the National Referral Mechanism are British, right? We can't be treating Brits and non-Brits differently. We shouldn't be doing that. That's discrimination. So so irrespective of what your immigration situation is, you should be treated to a very high standard, irrespective of your nationality, and that's why they shouldn't be conflated like that.
Thank you. We've also had a question here from somebody who is involved in the Care Review Watch Alliance, and is asking whether any of the panelists or ECPAT are involved in the care review for children's social care, and if any of the panelists are. Do any of the panelists have views on that? I think
Kamena would be ideal to respond to this question.
Yes, so the short answer is yes. I mean, Article 39 separately has been involved in the care review in terms of being sort of overseeing some of the kind of more problematic areas of the review. But as a sector working with young refugees and migrants, the Refugee and Migrant Children's Consortium put together a submission to the care review's call for evidence, highlighting a kind of range of issues specific to unaccompanied children, child victims of trafficking, but also children and families who are subject to immigration control. So some of those issues off the top of my head, obviously age assessments, because that's such an integral part of children's social care, but also issues such as the kind of placements that these children are put in, and the idea that actually decisions aren't always made based on what's in their best interests. They don't always have their voice heard when it comes to what happens to them in terms of whether they're placed in foster care or in unregulated accommodation. So we've tried to kind of put all those forward and tried to sort of emphasize that these children's needs really need to be kind of considered by the review.
Thank you. And I think, Laura, are you going to pick up the interesting question that's come in about possible organising some collective action around these issues?
Yes, thank you so much for that question, Leonardo. Obviously, please, everybody sign our Stable Futures campaign and sign up to the Children's Society campaign on guardianship. That's just really simple, a few clicks and you're sorted. If you have more time and capacity to get involved in other things, especially if you're working in local authorities or if any of the organizations that you're working with want to get involved, please just email us info@ecpat.com and we can have further discussions. I think we all agree that a lot of these proposals are absolutely horrific for children, and any way that we can all organize together would be really, really valuable.
Thank you. We are coming close to the time when we were due to end, but we do have one last question, which I'm wondering, Philippa, whether you might be able to pick up on, which it's a good question about how national security threat might be determined within the public order exemption changes. I mean, national security issues obviously have raised their head a lot over the last few years in the immigration context and in nationality context. But I wonder, Philippa, if you've got anything you'd like to say about that.
I think it actually has to be synergized with broader policies around this, and also our international obligations as well. So it's really in part about proportionality, but we can't have one set of policies saying one thing and one set of policies saying something completely different. I think one of the things I would raise within that, as Andy had actually mentioned, was the way that traffickers really adapt to these situations. They're not stupid, they're very entrepreneurial. And just to flag that currently, even with adults, you know, adults with previous criminal offences and offending behaviour and, you know, are being targeted from prisons, you know, and that certainly, we were heavily involved in the Operation 4 case, and that was exactly what was happening, and that absolutely feeds into this agenda. How are those people going to come forward? And if they do come forward, they could be subject to the public order exemption and then deported effectively, denying them an opportunity to give evidence in criminal proceedings. So so when we're looking, we've got to look holistically at this issue and not just see it in this narrow context, but in the context of the current national security policy, in the context of international obligations towards victims, the context of national obligations towards victims of crime, and towards children more generally.
Thank you, thank you. So we're absolutely come to the end, I think, of our session. I would like to thank everybody for speaking, and for all participants. Do make a donation to ECPAT's work. We'd be incredibly pleased to receive it. I hope everybody has enjoyed and learnt things from the session. I certainly have. And as I say, thank you so much for attending, and to all our panelists who have all been excellent. So thank you very much.
Thank you.
Thank you.
Thank you very much, everyone.
Thanks.